Hello everyone, welcome back to my channel. I'm Lavanya. In the previous class, we had discussed about the history of Sale of Goods Act, some of the important definitions, essentials of contract of sale, and classification of goods. Today, let's move further to the next topic, effect of destruction of subject matter of goods. Point number 1, goods not existing at the time of the contract. If the goods are destroyed without the knowledge of the seller even before the contract is made, then the contract is void ab initio. Void ab initio means void from the very beginning itself. For example, A agrees to sell 500 liters of coconut oil to B out of his total stock. Unknown to both A and B, the whole quantity of the oil was burned down sometime back itself. Now the contract is void. Second point, goods perishing after the contract of sale. In case of an agreement to sell where the ownership has not yet been transferred, in such a case, there are two specific scenarios to be discussed. Now, first one is in case of specific goods, the contract is void. For example, A agrees to sell his horse to B, the ownership of which would be transferred to B after 5 days. B agrees to purchase the horse. However, on the third day, the horse dies. Now, the contract is void. In second scenario, in case of unascertained goods, the contract is still valid. For example, A agrees to sell 500 liters of coconut oil to B out of his total stock. Before A could set aside the oil, the whole quantity of oil is burned down. Now, the contract is not discharged and A is still liable to deliver B 500 liters of oil. Now let us move to next topic, price. As per section 2 subsection 10, price means the money consideration for the sale of goods. It is one of the essentials of a valid contract of sale. The consideration in a contract of sale must be money. Goods in exchange of goods is barter. Money in exchange of money is exchange. But goods in exchange of money is sale. For example, A agrees to purchase a new car in exchange of his old car and to pay the balance in cash. Now, this is a contract of sale. So, if the payment is made partly in cash and partly in goods, then also it is considered as contract of sale. Price in a contract of sale may be fixed either by the contract itself or determined by the course of dealings between the parties, or it may be fixed by the third party who is also called as valuer. When the price is to be fixed by the valuer and if the valuer refuses to fix the price, the contract is void. Let's take an illustration to understand this concept better. Rohan agrees to sell Sohan 5 second-hand cars, prices of which shall be fixed by Mohan. Mohan refuses to fix the price. The contract is now void. If suppose Rohan had delivered 2 cars to Sohan and Mohan refuses to fix the price of 2 cars which have already been delivered, then Sohan has to pay a reasonable price and for the remaining cars the contract is said to be void. Let's look into the next topic, delivery. Delivery means voluntary transfer of possession from one person to another. Generally, delivery of goods may be made by doing anything which has the effect of putting the goods in the possession of the buyer or any other person authorized to hold them on his behalf. There are different forms of delivery. Let's look into them one by one. Now, first one is actual delivery of goods. When the goods are physically delivered to buyer, it is said as actual delivery of goods. Second point is constructive delivery. When it is effected without any change in the custody or actual possession of the thing, as in case of the delivery by atonement, it is said to be constructive delivery. For example, where a warehouseman holding the goods of A agrees to hold them on behalf of B at A's request. Now, the third one is symbolic delivery. When there is a delivery of a thing in token of a transfer of something else, that is, delivery of the goods in the course of transit may be made by handing over documents of title to the goods. For example, bills of lading, railway receipt, delivery order, or a key of a warehouse containing the goods is handed over to the buyer. The next topic is document of title of goods. Document used in the ordinary course of business as a proof of the possession or of the control of goods or claiming to authorize either by endorsement or by delivery the possessor of the document to transfer or receive the goods thereby represented. To put it in simple words, document of title shows that the person named therein or the person holding the document is the owner of the goods. This document can be transferred to any other person so as to make him the person entitled to receive the goods either by endorsement or by delivery. For example, bill of lading, railway receipt, multimodal transport documents, dock warrants, etc. are considered as document of title. Next topic is stipulation as to time. Time is classified into two categories: time of delivery and time of payment. Time of delivery is very much essential in the contract, and if the contract is not performed within the time, the contract is voidable. Whereas time of payment is not an essential part in a contract of sale, and if the payment is made beyond the time, the contract is still valid. However, time can be made an essential part by specific words. The last topic for the day is difference between sale and agreement to sell. Let's look into sale. Sale is an executed contract, which means to say sale is already completed here. Whereas agreement to sell is an executory contract, which means the contract is yet to complete. Under sale, the risk of goods lies with the buyer itself. Under agreement to sell, the risk of goods lies with the seller. Under sale, the property in goods passes to the buyer immediately after sale. Under agreement to sell, the property passes to the buyer only on certain specified future date. In case of sale, the buyer can sue for the complete price of the goods. In case of agreement to sell, the buyer can claim only for damages. In case of sale, the seller cannot resell the goods. In case of agreement to sell, the seller may sell the goods since the ownership is with the seller himself. That's it for this video lecture. Please comment below if you have any questions. We'll meet very soon in the next video lecture. Till then, happy learning. Stay tuned.